It is 6:02. I'm going to give maybe a couple more minutes for other people to come in, and then I will get started with our meeting. Thank you for your patience. Okay, everyone, I'm going to call it. I'm just going to get started. Welcome to the Microbusiness Town Hall. My name is Leslie Turek. I am the Chief Equity Officer, and I am responsible for microbusiness outreach at DCR. Thank you so much for finding time in your very busy day, I'm sure, to attend the Microbusiness Town Hall webinar. We really appreciate it. I first want to make sure that everybody understands that this webinar is being recorded. And then I have just a few very quick housekeeping items before we get started. I'll make it fast so that we can get right into the meeting, because I know everyone's very excited about this meeting. So this town hall is really set up into two parts. We're going to start with information from DCR, and it's going to be presented by our director, Amy Moore. Then once she has completed her presentation, she's going to cover a wide variety of topics for you. Then we're going to be opening up time for question and answer. I'm asking you to hold on to all of your questions until that designated time is available. And I'm really going to encourage all of you to really listen carefully to the presentation from DCR, because some of your questions might be answered by Director Moore during her time. Okay, there's just a few things I have to highlight really quickly too about the technology that we're using. Okay, first, I really appreciate it. I noticed that a lot of people have already put their first and last names on as their screen identifiers, and that's really helpful for us to keep ourselves organized on our end, especially for the question and answer period. If you're able to do that and you just haven't had time to do it yet, if you could put your first and last name, that would be fantastic. All right. So right now, and during the whole webinar, everyone is on mute, and you cannot unmute yourself. So we're going to do it kind of like in a classroom. If you're ready to ask a question, or you have a comment, or you would like to speak, you have to raise your hand. And in order to do that, at the bottom of your screen, you're going to see a little hand icon, and you just click on that icon and it will raise your hand and we can see that. So I have a whole team of people who are helping me out with this, and we're trying to keep track of whose hand goes up first and all of that good stuff. And we will do the very best that we can to make sure we get everybody time to ask their question, and that we that we unmute you in order. Okay, so when we're ready to unmute you, you will receive a notification from the system, and it's asking you to give us permission to unmute you. Once you accept that notification, then we can unmute, and then you can talk. Once you give us your comment or your question and you're finished, then we're going to mute you again so that then we can answer your question for you. The chat window is open. I've already seen a little bit of chatting, so that's great. It is open and available if you're not comfortable speaking. Like, I don't want to raise my hand. I don't want to be recorded on this webinar. It's totally fine. You can put your question in there because it will be monitored. And then at the very end of this webinar, there is a survey. I know how much everyone loves surveys. It will pop up in a separate browser window for you. It is 3 questions. 3 simple questions. I am asking you to please complete that survey for me. It gives me information on ways to improve communications and outreach efforts for microbusiness licensees. That's it. I'm done talking. I don't have anything else to say, so I'm going to hand it over to Amy Moore.
Thank you, Leslie. And just as Leslie said, thank you all so much for being available today. We're hoping that this won't be the last time we get to have a meeting all together like this. And I appreciate your patience with all of our technical arrangements. This is really the first time we've tried to do such a large public meeting online. So, you know, trying to arrange it in a way that we can be sure everybody has a voice when they are ready, if they'd like to have a voice. So hopefully it works. And of course, we'll make sure, as Leslie said, to monitor the chat for any issues. I see some now. Chat's going on, so that's good. I'm going to try not to be distracted by the chat. In fact, I will close it. Okay. Hopefully you all have seen our agenda for today. As Leslie said, I'm going to go through several of the topics that we know were of interest, give you, the kind of foundational overview, basic information that I have prepared. But then, like she said, we're going to have a question and answer period. And in fact, that's going to be the bulk of the evening. So as we're going along, please do jot down your questions. We got some questions ahead of time. And so at the beginning of the question and answer period, I'm going to go through some of those if I feel like I haven't addressed them with my notes here on our agenda items. And then, like Leslie said, we're just going to open it up. And I think we have this space at least until 7:30, but I'm really hoping that we'll be here as long as you guys still want to chat. So first item on the agenda, we had partners and raising capital. So this has obviously been of interest, I think, probably to all of you, and has been an issue of discussion since before the law even passed. So, I tried to take a look at the kinds of feedback we're getting, and we're hearing about all the questions that I'm going to cover today, or all the issues I'm going to cover today. We're hearing those through our direct conversations with you, the licensees. We're hearing it, secondhand, where so-and-so said this, and this is what everyone is worried about or everyone believes. And then, of course, we're also hearing through that recent round of feedback on our rule revisions. So, a lot of information coming to us. Particularly appreciate those licensees that are reaching out to us directly. I'll probably talk about that in a couple of different areas here. But let's talk about partners and raising capital. In that topic, there's at least 2 categories of things that I want to cover. There's financial partners and operational partners. And both of these things are allowed for microbusinesses. In fact, they're allowed for all licensees. So let's talk about first financial partnerships. So I've seen some opinions, heard some opinions floating around regarding that the department is treating comprehensive or medical licensees differently than microbusinesses in this area. And in some ways, this is true, but in most ways, it's not accurate. In a lot of the ways that we're hearing there's these differences, it's not accurate. But first, the differences, the reason that there are some differences is because Article 14 explicitly creates a difference that mandates some of our responsibilities, that mandates some different treatment. Specifically, there's the requirement that the department confirm that we have awarded microbusiness licenses to eligible individuals who are owning and operating the license. So that requirement doesn't exist for other licensees. And the other licensees also don't need to be majority owned by certain categories of individuals. So there are some differences that cause some differences in how we have to approach things. But I think it's important to note that in most of the areas where the law does create a difference, we're still applying similar standards or philosophy to all licensees for whatever the requirements are that apply to them. And I want to give you an example. So all licensees can enter into agreements at certain times regarding future ownership. And this has been a big topic of discussion. So that's why I'm picking this one as an example. So for those of us who have been working with licensees for going on 6 years or more now, we have some long-standing guidance for all licensees about these types of financial agreements for future ownership. And the basics of that guidance and all those discussions that we've had with our comprehensive licensees, what it all really comes down to are things like these agreements can't be effectively automatic. They can't be written in a way that really makes them or makes the future changes effective now with just lip service to department pre-approval. And I can't tell you how many conversations I've had with comprehensive licensees about this. Of course, those contingent promissory notes, all kinds of financial agreements and management agreements and consulting agreements, they can get pretty complicated. And so, we have industry attorneys calling us and saying, this particular financial institution has agreed to give us a loan, but they want us to put all these provisions in there that really tie our hands in ways that kind of ignore the requirement that's always been in place for pre-approval by the department. So the details do matter in those types of agreements, but it's really the same standard that we're applying to microbusinesses as we always have to comprehensive businesses. And we're looking at these types of future ownership agreements, and we're looking to see, are they written in a way that's compliant with law and rules? But then you have to, layer on top of that the differences between the requirements for microbusinesses and comprehensives. So, that kind of analysis is really relevant for microbusinesses in two main ways. Those agreements, if they're written in those ways that make it an automatic guaranteed transfer, the licensee is trapped into that future ownership change. It's inappropriate for all licensees. It's not permissible for all licensees. But for microbusiness, it goes to the analysis of whether that license is owned and operated by the eligible individuals. And that's a little unique to microbusinesses, but really just in the timing of when these agreements can happen. And of course, for other licensees, it's the same consideration about whether those agreements are ever compliant. So I know I'm getting into a lot of the details here on just one particular issue. What I would like to tell you is, in your particular circumstances, and this is what we've told comprehensives for years, you can send us a draft agreement for what we've always called a red flag review. We're willing to look at draft agreements, and I think that is particularly appropriate with microbusinesses where we're, tasked with giving technical assistance. But it is, like I said, something we've always done and offered that service to comprehensives as well. You can send us a draft agreement and we can do a review for red flags, things that, while we're not approving that draft agreement, We can tell you what things may not be compliant or that you want to watch out for. That's the type of collaboration that keeps all of us out of enforcement activities in the future. So red flag review, I'm going to mention something like that later as well, but really that collaboration is going to be to everybody's benefit. And we're here for that, and we have been. So I think that is probably one of my best examples I have of how we are offering the same kind of philosophy and standard between comprehensive and microbusiness. If you are hearing something different, I would just really encourage you to come to the source. Let us talk through with you your particular circumstances, and we can even explain how that's being consistent, and we're consistently applying that across the board. One more point on partners specifically. So there's nothing preventing any micro business owners from gathering a team of operational experts or investors around them through agreements or even ownership interest. You can do that. The law does set some parameters for ownership for micro businesses that again don't apply to other licensees. That majority ownership by eligible individuals is the pretty big one. But there's still opportunity here. So you can gather investors of any kind up to 49% of your ownership interests. We all know that. You can also partner with investors even more than that if they're also eligible individuals. And you can also enter into management and operational agreements. I've heard opinions that's something about what we're doing here or with our rule revisions would prevent you from doing that. It's not the case. The same kind of agreements that other licensees can have, you can have as well. Where we run into some issues is when these agreements are actually, say, handing over all control or profits to other entities. And, now I don't want to downplay, I don't at all want to downplay the unique challenges that microbusinesses face in gathering well-intentioned investment. I think it was evident to us here and others as soon as we saw the proposed law that this was going to be a big challenge, getting financial investment to the level and the freedom that you would normally expect from just a business because of the way that this framework was put in place. We also we'd seen for years how this plays out in other states too. And knew that this was going to be a challenge. So absolutely want to acknowledge that there are elements of this framework that make that particularly difficult. So we're aware of that. We're also willing to have honest conversations about that. I think where those conversations can be particularly beneficial would be in sharing ideas on what information we can offer you. Leslie's working on business resources. We have from the beginning been, collaborating with applicants and licensees on ideas for what can we offer in this realm of technical assistance that we are to give that doesn't overstep our expertise. So a lot of times we talk about that as what connections can we make, what existing trainings can we, pull in to ensure that you're aware of if you want to take advantage of that. So that's something that is a really productive conversation right now that I know Leslie's really interested in having. And so, on financial resources, talking to us about what you need and us talking to you about what we think we may be able to help with, that's really productive right now. So I want to say just with management agreements, operational agreements, agreements to partner up with expertise, just like with the financial agreements, I want to make sure that the offer is out there. If you receive one, you're not sure if it would be compliant or would put your license at risk, please do reach out to us. And, I know this relationship is new and we want to work on it. But all I can tell you is it's something that we've been doing for the comprehensives for years. We're not going to turn you down if you want to talk about that. and I hope that you would find it helpful. Okay, so let's move real quickly to the second topic, which was draft rule revisions. So I've got a couple things I want to hit on really quickly. First, I'm seeing some indication that there's confusion about this process that we utilize for our pre-rulemaking information gathering. So this is something we've done from the very beginning of the program, from those very first medical rules that had to be implemented so quickly. What we like to do is put our drafts out to our website, set up that portal for feedback, gather all the feedback as much as we can. You know, we think of it as just blowing the doors open wide. Who has something to offer? We're going to look at everything we get, and we're going to take what we can to improve our drafts. And we're going to do that until we feel like we have the best, best information implemented the best we can. And that's what we've been doing here. The point of confusion, I'm not sure where it's coming from, but I just want to clarify, this is not ever going to be emergency rulemaking in this case. That was something we had to do during the medical program, but this is not emergency rulemaking. That's separate. That's a very specific process that is allowable in state rulemaking under certain circumstances, and these aren't those. So I just want to put that aside. And if anybody wants to reach out to talk about a concern there, I'm happy to talk about it. But I can just say this is not an emergency rulemaking process. These rules are not drafted in a way that would make them emergency rulemaking. So instead, what we're looking at is the informal information gathering here at the beginning that we do. And if we decide to pursue these rules, then eventually we will actually file them, formal rulemaking, proposed rules with the Secretary of State, and it will go through the normal 6 to 8 month process with more public feedback and eventually ending with effective rules. So that's the first thing I wanted to clear up. Then real quick on the intent of the revision. So the primary goal of what we're doing here is to move that post-licensure deep dive investigation from post-licensure into the application period. And there's a lot of great reasons for doing this. And in fact, in some of the questions we received ahead of this town hall, I can see that you all are thinking the same thing we are and what would be the value of doing this. I'll talk about specifically the questions we got here in a minute. So the Constitution said that we have to do this 60-day review to verify that licenses were awarded to eligible individuals who are owning and operating. So we know we have to do that, and we still do have to do a post-licensure 60-day review of eligibility. So we're still going to be doing that. But what we're moving into the application period with these rule revisions is that deep dive review. So we'll have the application period, we'll have the lottery, and then we'll do verification of eligibility and that, that you are all, that the lottery, how to say this, when we do the lottery and it comes out with an order of applications, we're still going to do that same thing under these draft rule revisions, where we could start from the top and start going down and start reviewing everything. And the main benefit of that will be that if there are any, in this case now, applicants that are not actually eligible, we would be able to catch that before we issue the license. And I think you all can probably see where I'm going with this. If we catch that before we issue the license, then on that day when we issue the next round of licenses, we should have a full slate of completely compliant, barring any surprises in the next 60 days, we should have a full slate, fill in all of the gaps. A lot of those questions that we got before the town hall go to points like, are we concerned about the sustainability of this market? And yes, in fact, this is why we started these draft rule revisions. It is not sustainable to keep going through rounds of license issuance and then having to do rounds of revocations. We're never going to get this market fully built out, or it'll take a lot longer if we don't try moving all of this into the application period so that we can have in our third round, we can fill all the open spots. So that was the driving purpose of starting these rule revisions. Then also in there with those rule revisions, we're also trying to address things like the clarifying what that phrase in the Constitution means about owned and operated. And I think that's probably the last thing I'll talk about in rule revisions. You all saw in our draft that we have a clarification there. You've probably, it probably looks familiar to you from our press releases and our public discussions about that phrase. It's what we have been applying since that first license issuance. It's the same standard that we've been applying in that post-licensure verification. Again, we would just be moving it to the application period. That requirement comes to the Constitution itself. We're obligated to acknowledge it. We can't ignore that it's there. It's a unique requirement. It has to have meaning. So what we've drafted and what we've been applying from the beginning is the idea that the operations part of that requirement is just bolstering the ownership part. So owners really should be owners in the most usual form of the word. We certainly could have interpreted it to mean the owners must also be like the operational experts and in the day-to-day for the license, but we thought that that would have set up a larger burden for a license that should, by every other indication of law, have lower burdens. And so, we didn't think that it was reasonable in the context of everything to interpret things that far, but it has to have some meaning, right? So if you're seeing or hearing any opinions that our interpretation of that owned and operated phrase is creating like an unreasonable standard, I would just ask you really to think about how you would interpret that extra requirement. It's there, it has to have some meaning, like I said. The use of operate, and we may not have this exactly right, but that's part of this process of putting out those rule revisions and getting the feedback. We want to refine it. We want to make sure that we get the most reasonable interpretation of why it's there, what it must mean. So I think it also is important for you all to hear that we're really seeing a lot of variation around owners in this license type. So, from our seat, we see situations where someone is listed as the owner of a license who tells us that they don't own anything. They never had any intention of owning anything. Maybe they were promised a certain amount of money to use their name, or they were promised a job once the license landed with someone else. But then we're also seeing great situations where individual owners are really truly pursuing their business. They're partnering with friends who have, investment resources within the investment limits, or other friends that are eligible, or they're gathering their family and friends around them to build their business without committing to agreements that will automatically strip them of all benefit from the license in the future. So we're seeing really a range of things, and most of the first example would not be compliant with the law. Second example certainly would. So again, back to that red flag review idea, if you have any questions about how any of this applies to your situation, your circumstances, please do reach out. The fastest way to understanding what we're actually doing is to talk to us directly. And I think I said this before, please, I want you to understand we really appreciate those of you who are already doing that. That has been incredibly helpful for us, both to have the opportunity to explain what would be allowable and where the opportunity is, but also just to hear from you about your circumstances and where those challenges are. Okay. Well, last note about rule revisions. Many of the comments that we received were helpful, and I appreciate the thoughtful input that went into most of those comments. As is usual in this process, we're, like I said, reviewing all the comments for potential adjustments to draft revisions. I won't be able to go through those today. We did have a request, at least one request in the questions ahead of time that we do that we go through each of those and respond. Won't be able to do that today or tell you what will or won't be incorporated because those decisions haven't been made. But this is why I'm trying hard to talk about these things as what we may do or what the actual intent of the revisions were, or what we believe the effect would be. If we actually decide to move forward with revisions, we'll make those available to everyone at the same time. Okay, I've been talking a lot and I really want to get to question and answer. Let me just touch on variances real quick because it is something that has come up from interactions with compliance officers and our licensing folks and with Leslie. So first, I've talked to some of you before about what we can vary from. And essentially what it comes down to is if we made a rule ourselves based on the constitutional authority, but it is just our rule, then we have a rule that allows us to vary from those regulations or waive them with good cause. Now we have to treat that pretty carefully because those rules, they went through the public rulemaking process with public feedback and approval by several state groups. There's a reason that's in place. But one of the rules that was approved does allow us to vary. So we do take that responsibility seriously, and don't feel free to vary from everything whenever we would like to. So there's that good cause standard. But what we can't do is vary from something or waive something that is explicitly in the Constitution. So I couldn't decide that I prefer to allow anyone to hold these licenses and not worry about eligibility criteria, for instance. However, maybe I'm going to try to come up with a rule we don't actually have. Maybe we had a rule saying that your dispensary needs to be brick. That is definitely not something in the Constitution. And if we had that rule and someone wanted to vary from it, we would consider their arguments and whether there was good cause to vary from it. So that's kind of the first foundational issue with these variance questions, or questions about whether we would accept a variance request and consider it. That's the first thing to keep in mind. A specific topic of variance that we've been getting a lot of questions about is the operational deadline. That is a rule. That is not a constitutional requirement. So the potential for variance is there. But back to my discussion of treating microbusinesses and comprehensives the same, I'll start with some of the guidance that we gave our originally medical licenses as they were trying to become operational. So what we generally, I think, would like to see in a variance request is not just, I would like more time, but rather, what are your unique circumstances that create the good cause to do something different than what's in the rule? And that does not have to be, a 40-page argument crafted by attorneys. Just telling us your circumstances, what you've experienced, why you need more time, and hopefully something more than just, well, 2 years isn't enough. It should really be about your particular circumstances. I fully expect that there will be extensions. And I will tell you, it's pretty rare for me to give any indication of what a decision may be on variance requests, because we do really need to look at each circumstance and make a ruling. But I think that we're all very familiar with the challenges, not just in how these microbusiness licenses were designed, the framework they're in, but what has occurred in the life of this microbusiness program so far with all the revocations and an interdependent market. So I would just say what we would hope to see is everyone working in their own way, in their own situations, diligently towards becoming operational. If you find you need more time, just know that requesting a variance is an option on the operational deadline. That's not an Article 14 requirement where our hands are bound. Last thing, still on variances. We've gotten several questions about whether microbusiness licensees, wholesalers, dispensaries, whether microbusiness licensees are permitted to move districts. So I'm just going to briefly explain why you can, yes, you can submit a variance request. We will consider it. But I want to explain why I think this is actually in that category of a constitutional requirement. And it's the same situation that comprehensive dispensaries are in. And we've received questions over the years from comprehensive dispensaries wanting to move districts. And what we've always explained is we are under the mandate to issue a certain number of minimum licenses per district. That framework is there. Intent, sometimes we try to figure out what was the intent, how does this make sense so that we can understand the policy, but ultimately intent or what the drafters meant doesn't really weigh heavily, not just with us, but with courts. If I were to make a decision that someone appeals, it has to be defensible in the courts. So intent doesn't really matter so much for the decision, but it's certainly something that could help us understand. And it looks like there was a design here to ensure that the numbers of these licensees per district are even. For whatever reason, that's there. That's something that, again, kind of like the owned and operated standard, it's not something that we're really permitted to disregard. And you can imagine what would happen if we start allowing dispensaries, comprehensive dispensaries or microbusinesses to go out of the district when they were part of a minimum number for that district. Then we have openings, then we have to issue more. Who do we prioritize in allowing them to move? How many rounds do we continue to do? And how many total number of licenses do we end up with? Those are all potential effects that we'd have to deal with, but ultimately what it comes down to is the Constitution laid out that these licenses should be issued for a particular district, and we don't necessarily feel free to vary from that since it appears to be a pretty explicit constitutional standard. Now, I know some people have arguments about that. So like I said, if you still feel that you need to submit a variance request for that, then we will look at it and we will actually give you a decision. Okay, so I have been talking for a long time. I was going to go through some of the questions that we received ahead of time, but let me take a quick look here. All right. Looks like we've got a few in the chat. I might let the team look at those. Let me run real quick through those questions. For those of you who did take the time to send us questions ahead of time, I would like to honor that and try to respond. Fingerprinting. Someone asked, what's the next step for fingerprinting and has that started? Yes. If someone from my team wouldn't mind, could you find the information online and maybe post a link in the chat? We have started doing the fingerprinting for agent IDs. that, that criminal background check that we're required to do for disqualifying felony offenses. For owners, we are getting started with that right now. The online information you'll see is that we were going to start that in February, and that we would be reaching out to licensees. So that's what we're starting now. It's not going to be everybody at once, but we are prioritizing micro businesses, as that will be one of the things that we need to confirm before you all can move forward. So you should be hearing from our business licensing services unit soon if you haven't already. Someone asked why it's taking us longer to get final decisions out on this round of notice of pending revocations that we have issued. And the honest answer is there's more of them. We want to be sure that when we do issue final decisions on those, that we are really applying our reasoning consistently across all of the notices. So for the most part, we're probably going to need to do them all at once. There may be some categories of issues where we could group those together and go ahead and get them out, either to satisfy the NOPR, or if we have to move towards revocation. But that's really it. There's more of them this time. Another good reason to move that verification process into the application period. Okay, I'm going to read this one verbatim because I want to be a little careful with this one. The question was, what does the department plan to do to protect the needs of licensees, since our associations aren't a coherent representation of our micro network? How can we ensure a fair and neutral support group for our micro network licensees? So I feel that I have to speak about this one as a bit of an outsider, because I'm not part of your associations. I don't attend your meetings, and I really don't have any authority over how that plays out. But what I appreciated about this question is the desire for fair, neutral collaboration. So what I can offer is some of what I've already said tonight. This is a new relationship that we have with you. We've built our relationship with the comprehensive licensees over years, and I know that we have to earn your trust. But what I would like is for you to give us a chance to get to know us, get to know our expectations directly from us. Let us take the time to give you the fair, neutral information, at least, and to the extent that we can act as support in that way, we are certainly willing to do that. I think part of Leslie's role could go towards this, bringing licensees together for education opportunities, for sharing resources, just even having a place to go for direct information. I really don't know the answer to how the licensees themselves could build a fair, neutral support group, but to the extent that we can be support, I do believe that unique to microbusinesses, here's a positive difference. You know, we talked about some differences that are kind of tough, but here's a positive difference. Unlike comprehensives, we do have a particular role set out to support microbusiness licensees with particular activities that we are to engage in for that support. So to the extent that that's helpful, I do want to offer that. Okay. Someone asked us to officially acknowledge the ability for microbusiness wholesalers to transfer material between themselves. The answer is yes. Microbusiness wholesalers can transfer product between themselves, between other microbusinesses, so not to other to comprehensives, but between the microbusiness market, yes. For any detailed specific questions about and what types of processes or circumstances, we do have a document online called the Permitted Activities Guide, and maybe someone from our team could find that as well. And then your compliance officer will also be a great resource on, well, what about in this circumstance? What about this particular activity? Okay. There was one about having access to the metric system and the timing of that. So I checked in right before this meeting with our section for compliance and enforcement, and the answer was that once a licensee has requested a commencement inspection, that's when the facility and their employees will be eligible to sign up for that new business training course with metric. This has always been our process and timing. I can't say that I understand why then and why not earlier or later, but that's definitely something that we should talk about if anybody has a desire to be connected earlier than when you request a commencement inspection. You can reach out to your compliance officer or to Leslie. She'll help you get connected with whoever can help with that. How can we better streamline and expedite the process to commencement? So I'll tell you, I've had really good feedback from licensees who are in the commencement process with their compliance officers. So feedback about how helpful they've been, how much information and availability there is with their compliance officer. If you're in that process or working towards it, and you're not feeling like you're having that experience, please reach out to Leslie. It's something that we're pretty proud of, that we have those types of individuals as compliance officers who are really eager to help micro businesses in particular through the commencement inspection process. We want to make sure that that's what you're experiencing. So please do reach out if you haven't had that experience, or you want to be connected with a compliance officer and you're not quite there yet, but we can do that. Okay, two that are kind of related to what I was talking about earlier. Do you have any concerns that the delays in license issuance or the other one, or well, I'll read that one separately. So do we have any concerns that the delays in microbusiness issuance could collapse the microbusiness framework or market before it even gets going? Yes, we do. And that is one of, like I said earlier, one of the primary drivers for starting on this rule revision information gathering is because we really want to get a full slate of licenses issued so that everybody is there in the community and can be working towards commencement, because we do see how these licenses are all interdependent. I would say it was the same for the medical licensees. You know, there were unique challenges in going first with medical facilities as well. A lot of dispensaries waiting around. But as we all know, with the micro businesses, the limitations on the license, being a small business by design, all of those challenges are just exacerbated. Does DCR value the success of the microbusiness industry? Now, are we taking steps to help launch this network of interdependent businesses? So first, I will say yes, same response as before, but this one particularly also calls out, are there ways that we can prioritize things, like prioritizing change applications and commencement inspections? We are. I'm sure that there are ways that we can do better. So that's something, again, I would really like whoever submitted that to reach out to Leslie. We're doing things like with commencement inspections, prioritizing that relationship with compliance officers who are putting in extra effort to assist through the process, rather than comprehensive licensees. They often come to us and, you know, they've done a lot of work on their own. They're not really asking us for anything other than to go through the process. We're hoping that your experience is that the compliance officers are being really proactive to assist you through that process. Things like that. But yeah, we can talk more about that. Okay. There were a few other questions that were really specific to what I would say would be, you know, advice on what is required, rules. And so again, I think your compliance officer would be a great resource for things like can we explain how the definition of flowering plant applies to autoflowers? That would be a great one for your compliance officer. What are the likely deficiencies during the wholesale commencement inspection that will hold up approval? Another great one for the compliance officers, and that's one of the primary purposes of them wanting to be proactively available to you, is to avoid those kinds of things. And would we permit operations to commence even if we find some deficiencies? So yes, there are circumstances where that's true, where there are things you can go ahead and commence and you have a deadline, or 14 days, I think was the suggestion, to come into compliance with, fix this window or whatever, add a camera here. I don't know what the exact examples are. Another great question for your compliance officer. Okay, I think I'm going to stop for a minute and let's see if we have any questions. Team, do we need to address anything from the chat, or should we go to seeing who wants to talk?
Up to you. Which do you want to do first? We can alternate them back and forth. I do have a few people that have been hanging out with their hands up for a little while.
Okay, well, let's go ahead and get to some hands, and then if you want to jump to the chat, I guess those are hands up as well in a way. So I'll just follow your lead.
All right, I'm going to start with Kimberly Vincent. Go ahead, Kimberly.
First and foremost, I am very excited to have the opportunity with my micro license as a qualifying social equity applicant. Having said that, I'm into my attorney for about $3,000 now. So my question is, if DCR is trying to protect me from a predatory practice, please explain in detail, how is this protecting me and my micro license?
You're asking how your need for an attorney. I'm sorry, I don't understand.
After 3 interviews,
Okay.
to
Sure,
try to,
so
to
you're
try to keep my license, I've had 3 interviews and I've had to hire an attorney because I'm not answering NOPRs, even though they've been submitted. So if DCR is worried about the predatory practice, and I have said numerous times that I am not in a predatory practice, how is DCR actually protecting me and
Okay.
my micro business license?
Sure. So first, I think I want to reframe that a little bit. While protecting you from a predatory relationship, or anyone else from a predatory relationship sounds like a valuable thing to do, that's actually not our primary driver. Here at DCR, we have to follow the law. So for anyone who has received a notice of pending revocation, that is because we identified something in what had been submitted so far that raised concerns that we would not be following the law if we did not look into that further. So while none of us want to be in an adversarial process, everyone here would much prefer that eligibility and compliance with other requirements is very clear from the start. We have our duty to follow the law. And this is the process that you've described. That is us doing that Article 14 mandated post-licensure verification that we have issued these licenses to eligible individuals who are owning and operating the license. Once we get past that, and hopefully in your situation, you're able to provide information that shows that's the case, information that wasn't provided earlier. And if so, then we'll proceed and hopefully we have a great relationship going forward. But that's the process we're in right now. It is about whether or not we are following the law. And in this particular circumstance, us looking into compliance happens to be, at least, according to what you're describing, about whether or not there are compliant agreements that are not predatory, but really what's more relevant is whether or not those agreements show or don't show that the license is owned and operated by eligible individuals. So that's what we're looking at. And that's what we have to look at. Thank you for asking, Kimberly. Okay.
Okay, I have another hand up.
Okay.
I'm going to unmute Mr. Dillard. Go ahead.
That which there was a initial warning about these predatory practices, of just, be careful, be on the lookout, except for the thing with that warning is there are similar agreements that were approved of in the first lottery round. There was no saying that if you went into these sort of financial agreements that you would be stripped or would be denied of the license in the first place, especially since there were those initial round one lottery applicants that had very similar agreements that were approved of. So what exactly is the goal of kind of putting us in approval limbo when they were especially when we're attempting to work with you on the side of proving that we are in accordance with the rules laid out?
Mm-hmm. Sure. Yeah, so I've seen this a couple of times. I've seen discussion about whether or not agreements were identical that were approved before and not approved this time, or very similar, approved before and not this time. To my knowledge, and this is something that we'll continue to keep an eye on, but to my knowledge, this idea that there are all these agreements that were approved before and identical or similar ones are not being approved now is not the full picture. So what we are doing is looking at each licensee's bundle of circumstances. It has been very rare that the agreements are actually identical. And, I'm kind of at a disadvantage here because there are confidentiality provisions. I can't just pull them up and show you here are the differences, but it's very easy for others to say that there are identical agreements. But what I'm seeing is there are very few agreements that are identical, maybe none. I'd have to check on that. There are some that are very similar, but not only do we have differences in the agreements, we have differences in the rest of the bundle of circumstances that we look at as well. So our goal, and I think what we're accomplishing, is to look at every licensee's circumstances, and none of them as a whole are identical. And I understand, that's obviously a challenge for us in reaching a decision, that we want all of our decisions to be consistent, but there are no two circumstances that are exactly alike. But I also understand, I hear you, that makes it difficult to know how to proceed on your side because you can't see all of the examples and why one that you've heard about may seem similar. What was the difference that raised the issue for the department? So we're hoping with our rule revisions, with continuing to communicate, that we'll be able to guide applicants and licensees to what is permissible. And there's a whole world of things that are permissible. It's a lot of times it's the trying to ride the line that gets licenses into risk. But other times they're just, wildly non-compliant agreements. And I don't think that's what you're talking about. So I would just say, we'll do the best we can to communicate what are the standards that would be allowable, what kind of agreements are allowable, what arrangements are perfectly fine, and that will help everyone stay in the perfectly fine, steer clear of the maybe, maybe not, and definitely steer clear of the wildly non-compliant.
Okay, I'm going to ask a couple of questions from the chat. From Keegan Kimbrough. Amy, you were mentioning DHSS will review agreements beforehand. He would like to know, is there a charge for a red flag review?
No, absolutely not. We see that as this is not just, a service we'd like to offer to you, is helpful to you, it's helpful to us. Because we would much rather start out from the beginning with a compliant agreement and have no one, including our resources, expending time and money and angst in enforcement activities. So absolutely no charge. It's in both of our best interests to have some eyes on those things and assist you if we can in avoiding issues.
And Craig Flanagan followed up with a question on that and said, you stated you can look through agreements for red flags. If it is a replica of a previous department approved agreement, should there still be a need to have it looked at?
If you personally know that it is a replica of a previous agreement, you shouldn't need to, but you can, of course, run it by us and have us verify. I would just caution you, I'm hearing of people claiming that their agreements that they submitted were the same, and we actually know there are differences. So if you actually have yourself an agreement that is identical to one that we have reviewed before, you wouldn't need to run it through again.
There's a few other questions on here. Hitel Patel says, when will the cultivators be ready with products? Only a couple are ready and their prices are high.
Yeah. So this is something that I really the division don't have a lot of control over. That's one of those business decisions. And it's a bit of a chicken and an egg problem. Same, like I mentioned before, same with the medical licenses getting up and running. I know that cultivators, wholesalers are making the same kinds of calculations that dispensaries are, and when to invest the resources they have. Ultimately, I assume everybody is thinking about that next round of comprehensive lottery licenses. The Constitution says that the next time we open up comprehensive licenses, half of the openings must go, at least half of the openings must go to microbusiness licensees that have been operational for a year. I think everybody's probably aware of that, and that's likely a pretty big motivator, but there's just all kinds of business motivations that we don't have authority over and would really be up to the licensee. So if the question was, do I know of any more that are almost there? I personally am not really tapped into that. Without revealing any licensee's personal business, Leslie or Tara, have you heard that there are others that are really planning to be operational soon?
I have. I've heard from several that said they're ready to request commencement inspections. So,
okay, that's good news. Okay.
And I'll do a couple more for a chat and then we'll go back to the hand raise. Magnificent Messiah says, for those of us who see scaling to the comprehensive network after being operational for a year as a means to help raise capital for our startup now, can you elaborate on the process behind moving from the micro to comprehensive network?
Yeah, that's going to be an exciting day. So there really isn't a lot of process involved. at least not, established by rule or really, we don't have any behind the scenes process involved. When it comes time to have a new lottery, we do have some provisions in rule, and I haven't looked at this in a while, but we do have some provisions in rule that would just make sure that you as a micro business licensee who's been operational for at least a year can apply, can submit an application in the lottery without running afoul of that whole, you can't have ownership in both microbusiness and comprehensive. So there would be a moment in time where technically that's probably a violation to have, oh, you want a comprehensive, but you also have a microbusiness. But we have in our rules some consideration of that to help with that moment of transition. Definitely, as any of you get close to operational for a year, or if we start putting out information about a new lottery, let's talk. And those of you who are ready can help us develop any processes that we need. We'll want to share information about any challenges or questions you have and how we can help with that. I hope that answered the question.
And then Siobhan has a two-part question. If we ever run out of product in our independent market, can we request a variance to purchase product from the comprehensive market? And the
Great
second
question.
Oh,
Sorry, go ahead.
Maybe you can go ahead with that one, and then there's the second part.
Okay. So unfortunately, that's a really good example of one of those Article 14 requirements that I don't have the freedom to vary from. This prohibition, I don't know the intent or purpose, but this prohibition between microbusinesses and comprehensive licensees selling to each other is directly in Article 14. So that's one of those that I wouldn't be able to waive.
And then the second part of his question is, can we work with a comprehensive business as a financial partner?
So you can't share ownership, and that's another Article 14 requirement. What I think might get interesting is other types of assistance or partnership. I would say if you have ideas around, I don't know, brand sharing, licensing, those are the kinds of things we really like to talk about and make sure that we analyze fully. And then if they are potentially compliant, that we all agree on how that would be compliant. But there is that prohibition between having shared ownership between the comprehensive license and a microbusiness license. But there may be other ways to partner.
Okay, I'm going to jump back into the hand raisers.
Okay.
The next one is from Mr. Brodsky. Go ahead.
Hi. Thanks, Leslie. I hear what you're saying, Amy, but unfortunately, I think the DCR actions are a little divorced from some of the things you're saying. And I think some of these questions you're getting from folks are folks that have NOPRs. And one of the glaring issues that I'm noticing, because I received a NOPR in the first round, and in my NOPR, from the first round, it explicitly told me what we needed to change, or told us what we needed to change. And DCR actually worked with us, and it was great. It told us exactly what the issues were and what we needed to do. This round seems to be completely different. There's no indication of what we can do to cure. There's no mention of cure in the NOPR. It's kind of misleading. And we have a lot of folks have offered to cure any issues many, many times, and it's met with silence. So I guess my question is, when does DCR decide that they actually want to offer a cure and when they don't?
Mm-hmm. So a couple things. Whether or not there is a path toward becoming compliant is really dependent on the circumstances. And that could be the details of agreements, or like I mentioned earlier, any number of other circumstances around agreements, or other circumstances of the licensee or applicant. Regarding whether or not licensees are should have some kind of right to cure or fix problems. There is a provision in Article 14 that says before revoking, we must offer a reasonable time period for cure or response. I think you may actually be interested in a decision that just came out of the AHC yesterday in a case involving a licensee called Delta Extraction, you may be familiar with. There was a really detailed discussion of what that provision in Article 14 means. And it does not mean that, that the department is obligated to allow a licensee to kind of a second chance on compliance. There are a lot of factors, and some of them were discussed in that decision. A lot of factors that go into whether or not any particular violation can be cured. So yes, we must give that period of time with a notice of pending revocation to provide any information that you have to help us with our determination of whether the license should be revoked. But that doesn't mean that the law requires every licensee to have the chance to do something to fix a previous violation. So it has to be circumstance specific. And I believe that that's what we've been doing.
Okay, the next individual, I don't have a name. It says STMD. So if you would please introduce yourself when you come on, that would be great.
And my question would be that with everything that happened with Minnesota when they decided to change and move the eligibility and certification for applicants didn't work out very well, why do you think it's a good idea to do it in Missouri?
So I can't speak to the Minnesota circumstances, but what we are investigating right now is what do we need to do under our law to ensure that we are fully compliant with the mandate that these licenses go to particular eligible individuals. So yeah, can't speak to Minnesota and how that may be different or whether or not it worked out. But I think we all can see that there are things that need to be addressed, and this is the time for us all to be investigating the options for how to do that.
Okay, my next hand raise is Timothy Duggan. Oh, hold on a second. My chat keeps popping up. There you go.
I have two questions tied to debt on the project. If our initial group that has been approved and we're awarded a license, we're trying to get to commencement very soon. Are there any regulations tied to just taking conventional debt, not tied to ownership or management or any of that whatsoever, that we need to be cognizant of as we are moving forward with our build out? That's question one. And then two, if that debt comes from our group instead of just a typical lending situation, is there a threshold of a convertible note that is acceptable or one that needs to get approved for those two questions?
Great questions. Thank you. I don't think there are any restrictions or regulations on our part regarding traditional debt, loans from a bank. I understand that is difficult to acquire. And if it seems to me that sometimes the people who have them the best rates get the best rates in those kinds of situations, or even just access to that opportunity. It's often through existing business relationships or existing family relationships even. But that's always been a challenge for cannabis licensees. If you have that opportunity, I think it's great. But I'm not a financial advisor, so I'll leave the business side of that up to you. From our standpoint, there's nothing that would prohibit you from entering into a traditional loan. Now, on the convertible promissory notes, those are definitely possible, and that goes to the guidance that we used to have written guidance out on our webpage about the kinds of things that you would want to be cautious of in those financial agreements, and I've asked the team to work on getting that back out. We pulled it off, I think, just because during our rule revision, all the citations changed, and we're trying to update those things. So I'm hoping that we'll get that back out, and that should be helpful both in seeing what's possible, what to watch out for, and also seeing that it's really the same guidance that we had for comprehensives all along as well. Definitely possible for that one, because it can get so technical and specific. That would be a great conversation to have with someone on our business licensing team, and probably the easiest path to finding somebody with the most information to help you on that would be to go through Leslie, and she can help connect you with somebody who can talk about convertible promissory notes.
Okay, I have another. This one is John Payne.
Question is with regards to the red flag review. It seems like a lot of the, as the point of contact for a lot of these, I did see a fair amount of these NOPers on some of these, and they were, the notice of pending revocation was around drafts of agreements, and the rules that the draft rules that you're have out there also, make punishable, make discipline of the license possible by drafts of agreements. So how can someone send in something for a red flag review if even a draft of an agreement is grounds for discipline? That seems like it's, you're basically inviting potential discipline on the license, are you not?
Great question. So first of all, we did see the feedback on the issue of draft agreements and how that should or shouldn't affect our analysis of whether licenses were awarded to eligible individuals, and then of course going forward how that would apply to a licensee as well. So there's something that we are considering. What we have done so far regarding those draft agreements is in that bundle of circumstances that I mentioned earlier. There's, yes, an obvious difference between an executed agreement and a draft one. A draft agreement gives us, let's say, insight into intentions. Now that on its own may not be determinative for any situation, but that will always be relevant. Now, there's a difference between the review that we're required to do at the very beginning for an applicant, whether they're eligible for a license, and that 60-day review period. Did we award it to truly someone, an eligible individual who's truly an owner and operator? And then that analysis may be different for a licensee, particularly when they get past the period that by rule has always said, now is the moment when you can make changes to ownership in certain percentages. So it all has to go together. There's an analysis that we have to do at application, post-licensure verification in the 60-day period. Then there's our rules that are in place about when licensees can change ownership, rules for comprehensives as well as micro businesses. And then there's, the period after that. So it does all have to go together. I hear you on whether in our rule revisions it was or would be the best system to include those as required information or not. So it is something that we're considering.
Okay, we're going to go back to the chat for a couple more of those. This is from
Tara, just real quick, John Bertram says we lost sound. Can somebody confirm that you can still hear me?
Oh, yeah, I can hear you.
What about, okay,
Oh, we're getting some thumbs up over there on the side.
okay, great. I hope John can hear us.
Okay. This question is from Alan C. Do these proposed rules give the DCR the authority to bypass the Missouri Constitution by shifting the responsibility for license review and certification from the Chief Equity Officer to the DCR?
No. So the rule revisions would essentially beef up the review of the application, but there would still be the same participation from the Chief Equity Officer on the eligibility criteria, including that 60-day period for eligibility criteria review, where the Chief Equity Officer is the one that ultimately verifies that eligibility has been confirmed. So no, it would not change that part of what we do.
Okay, and this isn't so much a question for you, Amy. There were several questions about how long reviews take and things like that. Just so you know, I put in the chat, in case some of you aren't following, that we'll refer for your specific questions on your specific reviews to the appropriate DCR staff after this call. So we will be doing that.
Yeah, and I want to emphasize that we saw some questions in the pre-questions that were about specific circumstances and indications that people are still waiting on answers, and we want to make sure that's not the case. So we've already flagged those for follow-up.
And Amanda asks, can you please define DCR's interpretation of what operate means?
Yes. So that element of operation, I think I talked a little bit about it earlier. We know it has to mean something because it's unique and it's there. What we have so far, the meaning that makes the most sense to us is that it is kind of an affirmation of what you would normally expect of an owner. I mentioned some alternative interpretations would go a lot further than that and really require that those eligible individuals that are owning the license be the ones that are in the facility every day doing, leading the operations. That's not how we see it. That's not what we're, I just don't see any indication in the law that that should or would be the most reasonable interpretation. So the way we've talked about it so far is more in line of what you would expect the level of control and knowledge of the business that a normal owner would have. So it wouldn't be someone whose name is being utilized to get a license who tells us that they have no ownership, they never did, they were just in it for the, I don't know, $5,000 that they were offered to use their name. Maybe they've been promised a job in the future. That I think most people's understanding of an owner, that's not it. And really all we've been interpreting the operating part to be would be bolstering the usual idea of what an owner is. Now, in our rule revisions, if we did put those into rule, it has a more specific definition. We've received some really thoughtful input on how that definition should maybe be adjusted or expanded on that we're considering as well. So we're hoping that if we do put forward rule revisions, that it will be much more clear and, through the rulemaking process agreed upon, really, because that's what the rulemaking process is for. And I think everybody agrees that would be helpful.
Okay, and then Rena Patel Charles, and I apologize if I mispronounced your name, Rena. How does the state expect us as micro business to compete with the comprehensive side? They can sell product at a lower cost overall due to the amount of growers. There aren't many growers at this point, so they dictate the market currently.
Yeah. You know, we don't have any authority over how many plants micro businesses are permitted to grow and utilize as a wholesaler. We didn't have any input on whether the micro business market should be isolated from the comprehensive market. Absolutely, there's a challenging fact that the comprehensive market has been up and running for a long time now. So I can acknowledge those challenges. I wish I had more to offer on that. This feels like it's firmly in the realm of, I mean, the issues that you raise of things that were established for us as much as they were for you. We are interested in, like I said before, collaborating with any of you who have ideas on, are there resources that we can offer to assist with those challenges in that realm of technical assistance. You know, it's pretty undefined, broad term. Is there anything that we can offer you there to assist with those challenges? And then we continue to look at, somebody raised it earlier, are there things in our rules that that we have some freedom over to reduce burdens without also reducing public safety or public health? That's something that we continue to look at. So yeah, I'm not going to say that those things aren't tough. They're in the category of things that we can't vary from.
Okay, and there are comments within the chat. I don't see any really specific questions at this time in the chat.
Yeah, we're pushing up on 7:30 here. I don't want to cut anybody off. Oh, I saw a couple hands going up from folks who haven't asked a question yet. So do we want to try to do those real quick?
Yep, that sounds good. Nick Hall, I'm going to unmute you now so that you can ask your question.
Hey, my name is Nick Hall. Hey, I went to 3 outreach meetings before applying in the lottery, and at every meeting, there was a lawyer who laid out a process to form pools using a LOI. And at no time during the whole presentation was the red flag check mentioned, or it was service offered. And we find ourselves in a situation where a license has been NOPR'd due to an LOI, and it seems like it's kind of like doublespeak to say, like, we have this red flag check, but it's never been mentioned. We would 100% use this red flag check. And I'm just curious, like, what's the state's thoughts on not promoting this lawyer, but allowing this lawyer to talk, be in there while she talked, and then completely going back on and just nopering all these LOIs that was presented at these state presentations.
Yeah, if you could leave Nick unmuted, I have a question. We never sent any attorneys to these presentations. Are you saying this was let's say a third-party attorney?
Yeah, sorry, I got muted. Yeah, it was absolutely a third party, and it was absolutely stated that, this is not our attorney, but you were the state was definitely there listening. It's like having a cigarette salesman outside of a daycare center, handing out free packs of cigarettes. And to me, it's exactly the same. And it's like, yeah, I just was curious on your guys' thoughts of like, on the whole thing of like, well, I guess like, why wasn't the red flag mentioned before
Yeah.
this?
Yeah, I could.
Like if somebody had a LOI and hypothetically they just totally threw the LOI out inside of the whole cure 60 days, would that hypothetically get through? And then like, yeah.
Yeah, so for that last question, it really depends on all the circumstances. I can't say. But to your question about why was the red flag review never mentioned before, I think that there are things that we have learned, as just everybody is, with how this is all playing out. We're able to identify more and more what would be helpful. And so, that's something that we identified pretty recently as, oh, this is something we do. This would obviously be helpful to well-intentioned microbusiness licensees that are just trying to get good agreements in place. And I just think it's something that we failed to communicate early on and probably didn't identify as a necessary resource when a lot of us went into this thinking, we've got this small business with eligible individuals. Around the time we were doing our first licensing round is when in other states we started seeing similar issues popping up. So yeah, I think just full honesty, we're learning what would be helpful. And this is one of those things that it's become very obvious. We need to make sure we're communicating this is an option to you.
I also have Keegan Kimbrough. I'm going to go ahead and unmute you. Keegan, if you're talking, we can't hear you. You are unmuted.
Looks like
Maybe.
the audio keeps going in and out for Keegan.
Yeah.
Keegan, if you can get to the chat, okay, yes, we saw your test chat.
I just don't think you have any audio, Keegan. Sorry about that.
Feel free to put your question in the chat if you would like to. Okay. Oh. Well,
Ugh, that's too
cannot
bad. I'm
talk.
sorry, Keegan.
Yeah. All right. Well, I see we have a couple more hands raised from Kimberly and Nick. If you intended to still have your hand up, we can open it back up to you again. Okay, Nick's gone.
I'm going to go ahead and unmute Kimberly.
Okay.
Just a follow-up then. If copies or if drafts are included in the NOPRs, would that fall under the red flag review?
So the way I think of the red flag review is if a licensee in particular is thinking of entering into agreement, they can send us that draft and we'll take a look and we'll help them out. It's a little bit different in the application and post verification process where what we're mandated to look at is, did we award these licenses to eligible individuals owning and operating, et cetera. And so, that's a little bit different than forward-looking how can we help alert you to issues as a licensee before you get into something? The difference is that in that moment, that verification period, or during the application, what we are instructed to do is to see if it was awarded to licenses. So that makes it a little bit different. But again, whether or not the ability to change an agreement during that, as a remediation step or the cure period, whether or not that is an option, which could be seen as a red flag review. We've looked at your agreement, here are the problems. Whether or not there's the option to fix it at that point really depends on all the circumstances.
I also have a question from Bryce. Bryce, I'm going to unmute you.
Two questions, two questions, might answer both of them with one. But with the NOPRs, you said it is taking longer for the answers. Some of us who have won our licenses and hold them, or that affects a lot of us second rounders, even the first rounders as well. So do you have an expected date when that will be answered? And then second question is the NOPRs affecting the start date for round 3? And if not, do you have a potential date for round 3 to start? Thank you.
Okay. Great question. So to the first part, yes, we are aware that the ongoing unresolved NOPRs is causing uncertainty both for the licensees subject to a NOPR and also for the rest of the market. I don't have a date for when we'll be able to wrap that up, but I can tell you that a lot of time and resources are going into it, and I hope soon. Every intention that it would be soon. But to your second question, the resolution of the NOPRs is not affecting the third round timing. The biggest thing that's affecting the third round timing right now is those rule revisions. If we need to file those, then they will need to go through the formal rulemaking process and be finalized. And so that's a big chunk of time. I think 6 to 8 months is pretty normal. We really weighed that, struggled with it when we were trying to decide, is it best to move forward with investigating rule revisions, or do we go ahead and do a third round? And ultimately, what it came down to is all indications are if we do a third round, we're going to have some portion of those licenses dealing with NOPRs and potential revocations. And that, like I mentioned earlier, that just extends the time period. Another round would be necessary before we ever get to that minimum number to fill out the market. So while the decision hasn't been made on whether we actually file those rule revisions or, revised rule revisions, we did decide that it was worth it to at least go through this investigatory process, because ultimately, if we do this, if we move that verification period into the application period, in the long run, it will be beneficial, even though it causes a delay now. In the long run, it will be beneficial to everybody to have a full slate of licenses in the next issuance. And, we would likely have some application denials that we deal with, but that won't affect you all. And you'll have your full market available to work towards becoming operational.
Mr. Payne has his hand up again. I'm going to unmute him now.
Hey, so yeah, I had just a follow-up clarifying question on one of the earlier questions about people in the comprehensive market and ownership. So, what the amendment says is that someone cannot be an owner of both a micro business and a comprehensive license. But owner is defined as 10% or more. So someone could have like 5% in one and 20% in another, right?
I have to check on that. So you're right that there are differences between the definition of owner versus having ownership interest. And I think what you described is correct. During the application period, you cannot have a name appear more than once in any given application. But I believe once they become a license, then we're dealing with common owners and not ownership. But I haven't looked at that in a while, so I would have to verify that that's the case.
Okay, Keegan was able to write in the chat. He said, many grow near me are preparing the same exemptions. Can you or we share this same exemption? And I submit their exemption? Not sure what exemption he was meaning. Were we talking about an exemption?
Yeah, I'm not sure I understand that. Let me see if I can look at that. And I submit the exemption. Oh, I wonder if this is variances. Let me agree. Keegan, are you, like fence requirements and distance? Yeah, okay, so I think what, Keegan, you tell me if I'm off base here, but I think the question is about variances. And if one licensee gets a variance for, say, fence requirements, can that same variance apply to others? Keegan, does that sound right? Yes, great. Okay, so there are things that we have done in the past, pretty rarely, that we call blanket variances. And what that would be is if we find something in our rules that needs to be tweaked, that we have discovered it really should not be exactly as it was drafted, and that the change, the variance, should apply to everybody equally, we will put that out as a department initiated variance, and it would then apply to everybody in those circumstances. So if we do run across circumstances with micro businesses where we learn through experience, or even if circumstances change in the market or other laws pass, then we could issue a variance that applies to everybody. That is pretty rare because it's essentially, even though the variance authority is in rule, that would essentially be changing our rules as we go. But if we have a variance that applies otherwise, one person asks for it, in theory, they should be asking based on their specific circumstances. And so it should be pretty rare that those specific circumstances apply to someone else. So I would say if there's not a department initiated industry-wide or, let's say wholesaler-wide variance for a very particular thing, then what we would expect to see is that each licensee is presenting their particular circumstances that show the good cause for the variance that they're asking for.
I think I have one last question in the chat. Eric McSwain says the department should consider issuing more than the required minimum licenses to ensure a viable market, then allow licenses to settle back to the minimum number over time. The Constitution does not forbid that approach. Am I mistaken about that?
No, you're exactly right. And in fact, we've actually applied that concept of a buffer, having a few extra licenses in case, some surrender or are revoked or, something happens. Then by issuing a bit of a buffer, a few licenses above the minimums, we can protect against needing to do another round of licensing, which, you know, in the past, when licensing used to be done by scoring and ranking, much more involved and expensive process for applicants and the department, that was more vital, I guess. But it's a good point. And I don't know that we've actually talked about that internally yet, so I'm glad you raised it. It may be advisable to issue a few extras so that, you know, we don't disrupt everything by having it creep down below the minimums. So thank you. A healthy buffer. Okay, got it.
I think that's covering all of our questions. It's kind
Okay.
of your last chance to ask a question if you have one.
Thank
If
you all
not,
for hanging.
yeah, I
Yeah,
think
thanks.
we can wrap it up.
Yeah. Turnaround time for red flag reviews. You know, sorry, I keep giving you answers that are essentially depends. But I don't really have like a days or weeks kind of thing. A lot of times in the past, those red flag reviews have been of really complicated agreements, and so that takes a bit. But I'm not thinking it's weeks or months. I think it's something that we can get one of our folks to take a look at and help you out pretty quickly. I do want to take this question real fast, and then we have to wrap up. So Andy's asking for an overview of the commenting feedback for the new proposed rules, percentage in support versus opposed. I don't know that we could really evaluate it that way. A lot of the comments were explanations of issues that either, you know, someone identified with the rule revisions or that we hadn't addressed in the rule revisions. There are explanations of that and a lot of proposals for alternative language. So to some extent, I would say all of them were giving us proposed changes or things to think about. I don't think I would want to interpret that as being opposed, but you know, I would describe that as the nature of the comments rather than an oppose or support, is that almost everything we received was some kind of feedback for improvement. Okay, I know it's getting late and I have to let my folks go home at some point. Thank you all. I hope you all, most of you, found this helpful. I think having these is going to be helpful for us. I hope you will join us on our next one. And I think what I want to say as we go is please, if you have any openness to building a relationship with us, please do reach out, give us a chance to get to know us, to find for yourself if we are being helpful, if we are being consistent. Your feedback, your questions, for those of you who have reached out directly, so helpful. It's the experience of this program that everything gets better when we have feedback, even when it is enthusiastically provided and perhaps even let's just say I understand that things that we do will sometimes not get it right and sometimes will be upsetting. And even in those circumstances, please reach out. Our door is open. And in this case, with these licenses, we have a very specific door with Leslie here that is dedicated to you. So looking forward to working with you. And thank you for tonight.
Thank you. Please don't forget to do the survey after you leave the webinar. I would really appreciate it. Thank you.
All right. Good night, everybody.